1, 2, 3.
Stand by, Chairman. Testing, testing. Chairman's microphone, 5, 4, 3, 2, 1. Testing, testing. Witness microphone, 5, 4, 3, 2, 1.
The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recess of the committee at any time. We welcome everyone to today's hearing on oversight of the U.S. Copyright Office. I will now recognize myself for an opening statement. Today's hearing will allow us to assess the current state of the Copyright Office and the U.S. copyright system. Each year, core copyright industries employ 5.5 million workers, produce $1.2 trillion in economic activity, and generate roughly $180 billion in foreign sales. These industries also promote a wide range of artistic expression and intellectual thought. The Copyright Office plays a vital role in helping to uphold this system and in helping to ensure that works are effectively protected by copyright. Maintaining this vibrant copyright ecosystem depends on having an effective Copyright Office to oversee it. And we are pleased to be joined today by Karen Temple, the Register of Copyrights and Director of the U.S. Copyright Office. This committee held its last Copyright Office oversight hearing in 2015, 4 years ago, and a lot has changed since then. Notably, last fall, Congress passed the Orrin Hatch, Bob Goodlatte Music Modernization Act, which provides critical updates to modernize the music licensing system and better serve both creators and digital music providers. This historic legislation, which I was proud to help author along with the ranking member, Mr. Collins, and Mr. Jeffries, assists digital music providers with the licensing of musical works, while also ensuring that performers, songwriters, and other music creators receive fair market value for their work. The Copyright Office is responsible for implementing several features of the Music Modernization Act, or MMA, including aspects of the blanket license established in Title I of the Act. The Office's July 8th deadline to designate the Mechanical Licensing Collective and the Digital Licensee Coordinator created by the MMA is fast approaching. And so I look forward to hearing more about the status of the Copyright Office's work in implementing these and other provisions. The committee is also closely monitoring the Copyright Office's much-needed efforts to modernize its IT systems. In recent years, we have heard a consistent message with respect to the Copyright Office that the office must be modernized to meet the needs of the public and the copyright community and to reduce the backlog of pending registrations. The Supreme Court's decision in Fourth Estate Public Benefit Corporation versus WallStreet.com, which held that registration, and not merely the filing of an application for registration, is necessary before a copyright owner can sue for copyright infringement, further underscores the need for modernization of the office's IT system. Following the Fourth Estate ruling, I wrote a letter, along with Ranking Member Collins, asking Ms. Temple about the office's plans for reducing registration processing times in light of that decision. I appreciated the thorough response and her testimony on the same topic today on the office's plans to speed up the registration process. These efforts should remain a top priority for the office. Another timely issue is the upcoming expiration of the distance signal satellite television license at the end of this year and whether Congress should reauthorize it. Ranking Member Collins and I also recently wrote Ms. Temple a letter on this topic. Again, I appreciate the thorough response, and I hope we will be able to explore more of the office's rationale for recommending that the license be allowed to expire in light of the changing media landscape. In addition, the office has been studying the effectiveness of the Digital Millennium Copyright Act Section 512 Safe Harbor provision. This issue exemplifies the critical role that copyright law plays in balancing the needs of right holders to receive value for their works and the interest of the public in having access to information. I look forward to learning more about the insights the office has gained over the past few years in the forthcoming report. I thank Ms. Temple for being here today. I congratulate her on her recent permanent appointment as Register, and I look forward to her testimony on the important work of the Copyright Office. The gentleman from Virginia, the gentleman from Georgia, Mr. Collins, not that there's anything wrong with Virginia. The gentleman from Georgia, Mr. Collins, has been a good partner and an important leader on many copyright issues, and it is now my pleasure to recognize the distinguished ranking member of the Judiciary Committee for his opening statement.
Thank you, Mr. Chairman, and just for anybody out there who may have gotten any wrong impression, go Dogs. Okay. Mr. Chairman, thanks for having this hearing today. There are many ongoing copyright issues that deserve our attention, and you and I have a history of working on these issues together in a very bipartisan way. I'd like to see this committee focus more on issues like copyright that are critical to our economy and represent areas where we can actually legislate and get things done rather than redoing a lot of what we have been redoing recently. I also want to thank Ms. Temple for appearing before us today. It's good to see you, it's good to have you here, and it is good that you are permanently there, and I'm glad to have that. It's her first time appearing before us as the officially appointed Registrar of Copyrights, but she is by no means a stranger to this committee or to copyright law. Copyright is a right provided for by the U.S. Constitution. Strong copyright protections are critical to promoting innovation and creativity, and they're critical to our economy. According to the International Intellectual Property Alliance, core copyright industries contribute more than $1 trillion to the U.S. GDP and make up almost 7% of the U.S. economy. The Copyright Office plays a key role in this system, and we in Congress are fortunate to have their advice and analysis on numerous policy matters. Last year, the Music Modernization Act was signed into law. This is a bill of a culmination of years of work and the first major update to the music and licensing system in a generation. The Copyright Office provided its expertise throughout the process and is now in the process of implementing the law. We look forward to hearing how that implementation is proceeding and to continue to work with the Copyright Office to ensure that this law is functioning as intended. In addition to the Music Modernization Act, there are numerous other copyright-related matters that deserve our attention. Copyright modernization remains a priority, and the Copyright Office, as the copyright moves to a new IT system, we must ensure that it has all the resources that it needs to fulfill its unique requirement. I am still believing that it needs further change and needs to be continued in this, and I would hope that the librarian would actually join us in this and not hold us on this, because this is something that needs to happen. The committee has jurisdiction over satellite compulsory license for distant signals, as the chairman had mentioned, Section 119. We have heard from the Copyright Office about its belief that the license should be allowed to expire consistent with their historic opposition to statutory license. While not all expiring STELA provisions are in the jurisdiction of this committee should review those that are. We must also ensure the copyright system functions well for content creators and content users who rely on it. Too often today, we are seeing small creators effectively sidelined from enforcing their rights. That is why I'm glad to see that the team is back, and Congressman Jeffries and I are again with the CASE Act. And for those in here who sell the shirts, that is something important to me. In just a moment, if we forget the creators, if this body forgets that is the original idea, that spark, that hope, that dream, that idea, that music, that poem, that verse, whatever it may be, that comes from within someone, if we ever get to the point where that is not valued in our system, when we ever come to the point where in creative spark, in whatever genius it may appear, is not protected under our system, our basic civilization goes down. Because it is those moments of spark and creation and hope that the CASE Act would allow for people to enforce their rights. But it's also that spark that keeps us going. And it's not for us in this room. It is for those who are going to have that next spark tomorrow, that next song, that next dream, that next book, that next moment that will literally change the world. That is why I love being a part of this committee on most days. But we'll continue. Piracy also continues to be a problem. While registration pendency times have gone down, questions still persist about how to protect property rights properly as well as works are registered. Piracy can happen in seconds, but registration can take months. I commend the Copyright Office efforts to shorten pendency, but these are questions that we must consider. We must also work to ensure copyright laws, many of which are decades old, reflect the needs and realities of today's digital world. They are not in competition. They're in a mutual symbiotic relationship if we allow them to be, and we need that. Many challenges remain in the copyright ecosystem, but I'm committed to finding solutions. I look forward to hearing from the Register today and to continue the bipartisan work to strengthen our copyright system and ensure it is working for all creators and content users alike. And with that, Mr. Chairman, I yield back.
I thank the gentleman, and I will now introduce today's witness. Karen Temple was appointed Register of Copyrights and Director of the U.S. Copyright Office on March 27, 2019. After having served as acting register since October 21st, 2000, after having served as acting register since October 21st, 2016. Previously, she served as Associate Register of Copyrights and Director of Policy and International Affairs for the Copyright Office. Before joining the Copyright Office in 2011, Ms. Temple served as Senior Counsel to the Deputy Attorney General of the United States. She earned her JD from Columbia University Law School in my district and her BA from the University of Michigan. We welcome our distinguished witness, and we thank you for participating in today's hearing. Now, if you please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and beliefs? So help you God. Thank you very much. Let the record show the witness answered in the affirmative. Please note that your written statement will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Ms. Temple, you may begin.
Good morning, Chairman Nadler, Ranking Member Collins, and members of the committee. Thank you for the opportunity to appear before you today to provide important updates on the operational and policy activities of the United States Copyright Office. For nearly 150 years, the U.S. Copyright Office has been at the very center of a thriving copyright ecosystem, serving as the primary federal agency administering the nation's copyright law. During that time, the U.S. Copyright Office has registered over 38 million claims to copyright, representing even more individual copyrighted works. We have provided crucial advice on copyright law to executive agencies and courts, engaged in a wide variety of public educational outreach, and answering almost 200,000 public inquiries just last year. We managed over $1 billion annually in statutory licensed fiduciary assets. Importantly, through our traditional role as the key advisor to Congress on copyright policy matters, the Copyright Office has participated in every major update to U.S. copyright law, from the development of the 1909 and 1976 Acts to the recent Music Modernization Act. The Copyright Office's legal, policy, and regulatory activities support our cultural and economic well-being. As recognized by the U.S. Supreme Court, copyright is intended to be the engine of free expression, and U.S. copyright law ably fulfills that intent. Congress developed a thoughtful balance of rights, exceptions, and limitations which promote the progress of our nation's culture, from traditional creative industries to the flourishing tech landscape. With this robust framework of rights and limitations, it is not surprising then that the United States leads the world in both entertainment and technology. Indeed, according to recent estimates, core copyright industries represent nearly 7% of the total U.S. economy and add more than $1 trillion to the U.S. GDP. The Copyright Office is honored to be a critical part of this copyright ecosystem. Since the Copyright Office last appeared before this committee for an oversight hearing, we have made tremendous progress on a variety of initiatives, including in operations, law and policy, outreach, financial management, and modernization efforts, which are described in more detail in my written testimony. The Copyright Office work supports all affected by copyright. When many people think of copyright, they often think of major corporations and large businesses. But those are not the only ones who are supported and who benefit from copyright law. What is often overlooked is that copyright also supports and sustains small businesses, individual photographers and artists, first-time novelists and bloggers, garage bands, and independent filmmakers. By providing a way for these creators to make a living doing what they do best, copyright enriches our culture and enhances our daily lives. Every time I hear from an individual creator about the first time they registered a copyright with our office, or the first time they actually were able to make a living doing what they do best, I am inspired. It reinforces in a real-world and practical way the important work we and the entire copyright law do for our nation. This includes, of course, an essential framework of exceptions and limitations like fair use that also helps and support and sustain a vibrant and flexible creative culture. The importance of copyright to individuals and smaller businesses is one of the many reasons that the Copyright Office strongly supports a voluntary small claims tribunal. The Copyright Office has studied this issue for well over a decade, listening to the views from all sides, and has come to the conclusion that many simply do not have the ability to enforce their rights or contest claims of infringement. A small claims tribunal would go far in ensuring that those granted certain legal rights under the Copyright Act actually have the ability to enforce them. I look forward to continuing the Copyright Office's progress and service to the country. To help guide the way, the Copyright Office released a new strategic plan just 2 months ago. It identifies critical focus areas that will chart our course over the next 4 years. None of this work, of course, would be possible without the dedicated staff of the United States Copyright Office. During my tenure heading the office over the past 2.5 years, I have been continually amazed and inspired by their resilience, flexibility, and support during a time of tremendous Copyright Office growth and change. Copyright Office staff often work long hours with limited resources. Their efforts have resulted in the recent elimination of our backlog of pending claims and significant reduction in the processing time for registration applications. So I would like to take this opportunity to thank the exceptional Copyright Office staff for their contributions to the U.S. copyright system and the American people. I would also like to thank Congress for your ongoing support of the Copyright Office. I look forward to working with you closely as we continue to modernize and update the office and the copyright law for the benefit of all. Thank you.
Thank you very much. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Ms. Temple, the Mechanical Licensing Collective will be authorized to distribute unclaimed royalties to rights holders. We have heard from some stakeholders with an interest in the process. For example, I received a letter from the Recording Academy on this topic, which I ask unanimous consent to place in the record, without objection. Ms. Temple, what are the Copyright Office's views on how the MLC should handle the initial distribution of these funds? And in the Copyright Office's opinion, what are the best practices the MLC should employ to ensure that unclaimed royalties have a chance to reach the owners of works that are currently unmatched?
Thank you very much for the question. As you know, we at the Copyright Office, and I know Congress, believes that the most important aspect of the Music Modernization Act is to ensure that songwriters and musical work copyright owners are actually getting paid for their work. One of the issues with respect to the Music Modernization Act and the MLC will be distribution of those royalties to everyone who's entitled to them. We were very pleased that both of the submissions by entities who have been requested to be designated as the MLC have made this one of the priorities in their submissions. We are also looking forward to working with Congress to ensure that those royalties are distributed appropriately. For example, under the MMA, we are required to do a study on best practices to ensure that matching is working appropriately and to reduce the amount of unclaimed royalties. So we will be beginning that report shortly after the designation, and that report will be given to Congress as well as to the designated MLC in July of 2021, and they are expected to follow the best practices that the Copyright Office actually provides in that report. And additionally, we were pleased that both of the entities that wanted to be designated as the MLC have agreed that the first distribution of unclaimed royalties cannot occur until 2023. This will give them both an opportunity, or the designated entity, an opportunity to ensure that they have good practices in place to make sure that they are able to distribute to the most people and have the least amount of unclaimed funds.
Thank you. And once the Mechanical Licensing Collective is designated, the Copyright Office will have to draft rules for how this entity will function and operate on a day-to-day basis. How does the office plan to conduct the forthcoming rulemaking proceedings, and how will you engage stakeholders, including the new mechanical licensing entity, in that process?
Yes, we were very pleased at the amount of regulatory authority that was provided to us and the confidence that Congress provided to us in the implementation of the MMA. We're focusing, as you know, right now on the designation of the MLC, which we will do by July 8th. After that designation, we will immediately start working on the regulatory other aspects of the MMA implementation. We have to provide regulations, for example, about the notices, the form of the notices of blanket license, notices with respect to usage. We have to provide regulatory information about privacy and confidential information. So we will be engaging in those rulemakings immediately. And then we also have broader authority under the MMA to effectuate the statute by regulations. And so we will look into whether we need to do additional regulations once the MLC has been designated as well.
Thank you. And I'd like to ask you about the upcoming expiration of the distance signal satellite television license under Section 119. One concern I frequently hear is that letting this statutory license expire will result in thousands of people losing access to television. Since the office supports letting the license expire, what's your response to this concern?
Yes, we have studied this issue in the Copyright Office for several years. As you know, we issued 2 comprehensive reports several years ago recommending that Congress allow that Section 119 license to expire. Recently, at your request, we reviewed and analyzed those issues again. We concluded that in the last 5 years, between 2014 and 2019, the actual royalties that we received under the Section 119 license has dropped precipitously. So it's dropped by between 85% to 99% in terms of the royalties that we come in. So that license is really not being utilized in the market. Also, we also noted that the marketplace has risen up to address issues with respect to satellite transmission, and that those underserved markets are not being underserved in the way that they had been in the past. The Copyright Office has always said that we view compulsory licenses as only needed in market failure. And in this instance, we have concluded that there is no longer a market failure that justifies those licenses.
Thank you. Let me get in one more question. I remain concerned about the pace of IT modernization at the Copyright Office, especially in light of the recent Supreme Court decision in Fourth Estate Public Benefit Corporation versus WallStreet.com, which clarified that registration is a precondition of filing an infringement lawsuit. In your view, what aspects of the Copyright Office are in most urgent need of modernization, and has the Office's strategic plan prioritized addressing those needs? My time has expired. The witness may answer the question.
Thank you. Yes, we agree that IT modernization of the Copyright Office is one of the most critical priorities for the office. It was listed as a primary and core key focus area in the recent strategic plan that I just released. In terms of which areas need to be prioritized with our IT modernization, I will have to say all of them, because we desperately need to have a full enterprise copyright system that is an integrated system that addresses both our recordation aspect of the Copyright Office, our registration, and our public records. So we are actually engaging in modernization efforts on all 3 of those different areas at the same time because they are such a priority.
Thank you very much. My time has expired. I now call on and I recognize, I should say, the ranking member, the gentleman from Georgia, Mr. Collins, for his questions.
Thank you, Mr. Chairman. In 2013, the Copyright Office recommended the creation of a small claims court and recommended legislative language that eventually resulted in the Case Act that Mr. Jeffries has done so eloquently talking about, and I've joined with him in that H.R. 2426. In your testimony, you discussed some of the challenges faced by small creators in the office support for small claims tribunal. Can you talk about this and your support and how we would go about that?
Yes, the U.S. Copyright Office has supported developing some type of alternative forum for small individual creators and smaller businesses for some time. If you may recall, Representative Smith had a hearing in 2006 on this very issue in which the copyright testified and said that this was a worthy issue to study. In 2013, we provided a full report after a public process where we received a number of comments looking at this issue. We concluded that, unfortunately, with respect to the current system, due to the high cost of federal litigation and the complexity, many individual creators and smaller businesses are essentially precluded from getting into federal court to really protect their rights. And we have noted that having a right without a remedy really means that you have no right at all. And so it is our strong view that we have to provide some alternative forum to allow for those individual creators and smaller businesses to be able to protect their legal rights. We noted, and others have noted, for example, that the median cost of a litigation is over $200,000 to be able to litigate that to a jury trial. And so that is something that is really just beyond the ability of most individual creators and smaller businesses. And so that's why we strongly support the creation of a copyright claims board.
Yeah, and I think it's in this so did in this audience today. I think this is something that again, we don't often go to the doable here many times. This is doable and should be as we go forward, and I think it's something that would really work. I want to go back, let me switch gears, and I want to come back to the office itself. But the committee recently received information from you regarding registration processing times, and I read that letter to say that registration backlog was basically gone. Is that correct?
Yes, we were very pleased that we were able to eliminate our historic backlog of pending claims.
What does that actually mean, and how does that how do you avoid a return to a backlog?
That's a great question. We have typically counted our registration backlog of pending claims to be over 150,000 workable claims. Those are claims on hand that have all of the materials that we need to be able to process the actual registration application, including the fee and the deposit, and that are pending within the office. So that's traditionally what we have identified as a backlog, and we have gone significantly under that in the last year. But we do realize that most people aren't as concerned about our backlog. What they're most concerned about is the processing time itself. So we have really kind of switched away from focusing on the backlog to focus on what is the processing time for our claims. And we were very, very pleased this year to be able to say that we have, within the last 2 years, reduced the processing time by 40%. It's now not perfect, but it stands on average at 5 months, and we are working very, very hard to continue to improve that.
Elaborate on the dependency issue. What's a problem that would keep you from getting better at that under 5 months?
Well, one thing that we identified, or I identified in my recent letter to the committee, was resources. One of the issues that caused our backlog and caused us to have very high pendency times was that we actually had a reduction, I think, of more than 30% of our staff over the last 5 years, or before the last 5 years, between 2010 and 2014. We lost a significant number of our registration specialists. We were very pleased that the committee has supported the Copyright Office getting more resources. So in FY 2015, 17, 18, and 19, we did get additional resources from Congress to hire additional registration specialists. So having the resource to hire staff is one of the most critical aspects of us being able to continue to have that processing time go down. Obviously, another key aspect is modernizing the office. Our system right now is not the most efficient, and we expect that once the IT system is modernized, we will be able to maintain and even reduce processing times further.
Look, I understand the delicacy of your position, and especially in dealing with the librarian and the Library of Congress as well. But it's an untenable situation. I'll take the heat for this. The librarian can come see me about it. I don't care. But this is the IT part of this, and the other functions that you need to actually have an office that works has got to be. There's no turf battle here. In fact, there needs to be a removal of you from that turf altogether. But we need this IT issues, and we need this to be broke up in a way that you understand the jobs that you do. I think you've done a great job, and previous registrars as well, Ms. Plenty and others have done a great job of saying why you're different. You want to. The thing that has gotten me the most is y'all seem to want to work within a broken system. It's best I've ever seen, but yet you continue to get hindered at every time. So we're looking forward to moving more in that direction. I'm glad you're here. Thank you for your help, and I yield.
Gentleman yields back. I now recognize the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman, and thank you, Ms. Temple, for being here today, as well as your terrific staff. In all of the interface I've had with the office, I've been impressed by the dedication of the staff of the office, the commitment they have to the rights of people who are seeking protection, and I just want to thank you and them for your hard work. We have an interesting situation. Actually, the House Administration Committee has jurisdiction over the library and every component within it, and we actually have had oversight hearings relative to the Operation Office. The copyright policy is the jurisdiction of the Judiciary Committee. But in terms of the IT system, we have received very strong commitments from the librarian as well as from you that the IT system is well underway. And really, I think that it was neglected for too much for a long period of time. We're playing catch up now. So I'm wondering, could you give us a little more detail on the IT improvements and when we can expect to see them come online?
Yes, that's a great question. We have been working hard to improve our systems for some time. We've been in the planning stage for a long time, but we are now right in the position to be able to realize some concrete successes from the modernization plan. So right now we have 3 different areas, again, that I mentioned that we're focusing on. We're excited about our recordation modernization. As you may know, our recordation system is still paper-based.
Correct.
So that is something that it was long in need of modernization. We have been working on that for some time. According to our OCIO, who is actually here today, we are going to be able to release a public launch a public pilot of a new digital recordation system early in the spring of 2020. And so that will be
next year,
That will
less
be
than a
next
year
year
from now.
Yes. So that will be a tremendous, I think, advantage for the.
Mr. Chairman, I wonder if we could have a little order so I can hear the witness.
We will be in order.
That will be a tremendous, I think, advantage for the public to be able to actually see this new digital recordation system. The pilot will be small in nature, but it will enable us to get feedback from the public on necessary improvements as we continue to develop. We are also working on our public records system. We are in the process of contracting with vendors to be able to develop our public records, and those are our records of applications, registrations. The goal, of course, is to be able to connect our applications, our registrations, and all of our data in one system so that the public will be able to get as much information as possible about copyrighted works and copyright ownership. So we're in the process of doing that. And then we have been working on...
And what's the date on that, do you think? I mean, this is good news overall.
Yes, we are hopeful that we would be able to have a pilot of the public records system late next year, so late in 2020 as well. Again, that would be a limited pilot, but it would allow for us to have something concrete that a limited amount of the public would be able to utilize to provide input and feedback to us as we continue to develop that system as well. And then finally, we have been working on our registration system that is part of the overall enterprise copyright system. We have been engaging in a lot of public interface to develop the frontal portal of that system. We have wireframes that we're working on. We've tested that system, the wireframes at least, with the public, and we're going to continue to do a number of kind of usability testing, UX, UI processes over the course of the next several months as well.
So really, we're on the verge. In the next year, we're going to see a huge change in the IT in the office. And I think that will benefit rights holders greatly. And, you know, the whole trick here is to find out who to pay and to pay them. And that's really a matter of information and the ease of information. Let me ask you just a quick question on the consent decrees. I realize that that's really not up to the office, but DOJ is now renewing its review of this. I don't know what's changed since the last time they looked at it, but it does seem to me that for a broadcaster to be fully covered for any song that might play, the broadcaster has to purchase a blanket license from all four PROs. You know, to me, that seems complicated and expensive. I'm wondering if the committee asked you to, whether you could study in the Copyright Office, whether Congress should modernize blanket licenses for the performance of musical works the same way it modernized sound recordings and mechanical licenses. Would that be something that would divert the office from its necessary IT upgrades, or would that be something that could be accommodated?
Certainly, if Congress would like us to review that issue, we would be pleased to do so. We obviously have been monitoring the consent decree process on the IP side. The DOJ is reviewing it on the antitrust side. This is an issue we touched upon briefly in our music licensing report that we issued in 2015, where we did recommend, for example, that we migrate any rate setting to the CRB to be more consistent. So again, certainly we would be definitely willing to continue to review that issue with Congress if you thought that would be.
My time is over. Thank you, Mr. Chairman, for indulging me in that latest, and congratulations on your appointment, Ms. Temple.
Thank you.
Oh, yes, I am remiss in not congratulating you also.
Thank you.
And welcome. The gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. Ranking member's gone, but go Wahoos. I want to thank you for your leadership, and Ranking Member Collins also, Chairman Johnson and Ranking Member Roby for their leadership on intellectual property, and Congressman Jeffries for introducing the CASE Act. I'm proud to join him as a co-sponsor of that bill. And congratulations to you, Ms. Temple, on your appointment. You've done a great job, and we look forward to many years of leadership from you. Copyright's particularly important to my home state of Virginia. We have had around 100,000 registrations from Virginia over the last 6 years, 12,000 jobs through the motion picture industry, and 2,500 production-related jobs. And the software industry in Virginia has accounted for over 180,000 jobs. Copyright ownership brings jobs, steady wages, and money to our local economies. And we're here, and we've been discussing many of the issues surrounding copyright, including modernization of the Library of Congress, copyright registration process, music modernization implementation, consent decree, stellar reauthorization. I want to focus on digital piracy for a moment. It's an oldie but a goodie, but your office is studying Section 512 of the DMCA, which is coming up on 20 years of anniversary. Notice and takedown is a critical part of copyright protection, but a lot's changed in 20 years. Many advancements have not been anticipated. Can you talk at all about the study, how it's going, and when you plan to release it?
Yes, we agree that a lot has gone on in the last 20 years, and that's why we were very pleased when Congress did ask us to study Section 512 and the notice and takedown regime. We are in the process right now of analyzing all of the comments that we received. We received over 90,000 individual comments on Section 512 and whether it is operating effectively today. We also engaged in a number of roundtables. Our most recent roundtable was just earlier this spring, where we wanted to make sure that we had all of the information in terms of updates that might have occurred since our last set of written comments were requested. So we now have all of that information, the 90,000 comments that we are going to read, each and every one of them, as well as the transcripts from the roundtables, and we will be drafting over the summer. We are hopeful that we will be able to release that report by the end of this year.
Thank you. And as you said, it's an important issue that you've received a lot of comment on, and video streaming piracy is costing the U.S. between $30 and $70 billion annually, between 230,000 and 560,000 jobs, and between $45 and $115 billion in GDP. Can you explain how the office continues to monitor video streaming piracy and how you're working to address the threat of piracy in this ever-changing environment?
Yes, we, obviously are not an enforcement agency, but we do work closely in the interagency with the rest of the USG to ensure that on the policy side we have strong protections against piracy. That's, for example, one of the reasons why we testified several years ago on the issue of illegal streaming. We noted that there has been an increase and a rise in illegal streaming even years ago, and that it would be appropriate at this stage for Congress to consider providing parity in terms of the penalties for unauthorized reproductions, distributions, and public performance. Unfortunately, under our current law, unauthorized public performances actually are not able to be charged as a felony, while unauthorized reproductions and distributions are able to be charged as a felony. As many of you know, streaming has risen in the type of distribution model that has been done by the content industry, and so it's our strong view that it's appropriate for Congress to consider providing parity for the penalties of all of the types of piracy that's out there, so that the Department of Justice will have effective tools to combat piracy.
Thank you. And with a few seconds remaining, I want to address something you mentioned in your testimony, the 8th Triennial Section 1201 proceeding that's going to begin next year. You adopted a streamlined process during last year's rulemaking when you recommended the renewal of exemptions for all 22 types of uses covered by the 2015 rulemaking, and you supported the expansion of 7 of those earlier exemptions, the adoption of 2 new exemptions. Can you speak to the work that you're going to be beginning and whether you see anything different on the horizon?
Yes, no, we were really pleased at the outcome of our last Section 1201 rulemaking. We did, as you noted, introduce a streamlined process. That process worked very, very well. So for those exemptions where there wasn't really a change in the marketplace since our last proceeding, we instituted a process where an individual could come forward and basically note that they were going to be relying on the evidence of the last triennial rulemaking, and then they wouldn't have to actually resubmit all of that evidence again if there weren't changes in the marketplace. And that allowed for those exemptions where there weren't really a significant amount of opposition for us to really be able to thoroughly analyze the previous record yet again, but not have the burden of those who are proponents of the exemptions having to provide a new record that really had not changed. And that streamlined process is the process that we will be following for the upcoming triennial as well.
Great, appreciate it. Mr. Chairman, I yield back.
Gentleman yields back. The gentleman from Georgia, Mr. Johnson, is recognized.
Thank you, Mr. Chairman, and thank you for hosting this hearing, and thank you for your presence to testify, and congratulations to you. I understand that the Copyright Office's IT systems are centralized as part of the Library of Congress's interoperable software programs. As a result, the Copyright Office must provide funds for its IT modernization to the library, only for the library to, in turn, provide the new services back to the Copyright Offices. What safeguards exist to ensure that funds designated for the Copyright Office's IT needs only serve the Copyright Office's needs once they are transferred to the Library of Congress?
Thank you for the question. As you know, after centralization of all of the IT systems, with management of the IT systems within the library, our IT is now under the authority of the Office of the Chief Information Officer. The way that we do request additional funds for IT developments is we do have our own appropriation line, and we do request specific IT modernization funding. Once we receive that funding, we do transfer that funding to the OCIO for use in the development activities. Under the appropriations law, they are required to utilize those funds and resources solely dedicated to Copyright Office modernization. We do want to work with OCIO, though, to ensure that that it is a transparent process, because we know that stakeholders want to ensure that their money and any fees, for example, that are going towards modernization are going specifically to Copyright Office modernization. So we're going to work with OCIO to ensure that we do have even better communications and more transparency in terms of the usage of our funds for IT modernization.
All right, thank you. How have modernization efforts in the Copyright Office been impacted by having to operate within the Library of Congress?
Well, you know, it's certainly, you know,
I guess maybe I should ask, have the efforts of the Copyright Office been negatively impacted by having to operate within the Library of Congress?
Well, I will say that it's certainly a change. We previously did have, for example, direct access to vendors where we were kind of, the business was guiding the IT development. And so one of the issues that I know is important for myself as well as the rest of our staff is just to ensure that in this new framework that the Copyright Office still does have that direct access to the vendors, to the contractors, so that we are actually the ones who are guiding the modernization efforts. Of course, the library also has a lot of priorities. They are modernizing other aspects of their systems as well. And so the other issue that we want to ensure is that when there are all these competing priorities, obviously we feel that the Copyright Office IT system is the #1 priority. And so it's my really hope that the librarian and the library will continue to have IT modernization of the Copyright Office as one of its highest priorities. And so that's really what we are focusing on, ensuring that the business requirements and needs that we have for the Copyright Office are conveyed and listened to by those who are developing our system, and that our system development remains a priority even among competing interests as well.
All right, thank you. Well, you'll keep us abreast of how things progress.
Yes.
The distant signal satellite television license is set to expire on December 31st, 2019, and in your letter you reported that the use of the Section 119 compulsory license has decreased in the past 5 years, but there are still over 870,000 subscribers. If we allow the compulsory license authorization to expire, then what will happen on January 1, 2020?
Yes, we have said, in our review, that the marketplace has already risen up to address this issue, and so we do.
How so?
In order, for example, the marketplace, you have different ways in order to get signals. For example, you can now watch on YouTube. Streaming services have risen up, and
Well,
so
now with broadband having not been extended to the far reaches of our society, of our country, that poses a problem.
Well, I will say that, in our review, we did hear from the satellite providers that there were about 800,000 subscribers, but one of the issues that we mentioned was, one, the royalty rates have gone down significantly. Again, that was an 85 to 99% reduction in the royalties that we receive, and even for that 800,000 numbers, it is not clear that those are all actually subscribers within households. Some of them are RVs and other types of entities, and so we don't think that there will be a significant harm to rural communities by allowing this license to expire. Again, this is something that we actually supported for many, many years. Over time, I think that it's even gotten better in terms of the marketplace, so we think that even if it was something that was useful a few years ago to allow the marketplace to take advantage of all of the advancements, it's even more so now because of the limited use of that particular license.
The time of the gentleman has expired. The gentlelady from Alabama, Ms. Roby.
Ms. Temple, I want to thank you so much for coming here and testifying today, and thank you for the time that you've spent with me in my office, and congratulations, and I look forward to working with you on ways that we can ensure our copyright system is working efficiently and effectively. So again, thank you. As the co-chair of the Congressional Songwriters Caucus, I'm particularly interested in effective implementation of the Music Modernization Act, and I know the chairman touched on this, but to ensure that songwriters are getting paid accurately and fairly for their work. And under the MMA, the Copyright Office must designate an entity to serve as the new mechanical licensing collective by July 8th. And we talked about this some in my office, but as you review the submissions and prepare to make regulations to implement the MMA, can you speak to the ongoing transparency and oversight responsibilities of the MLC to ensure correct matching of data that will help ensure that songwriters are paid fairly? And then I'll just add one more thing. What would you recommend that we in Congress, and particularly this committee, do to provide meaningful oversight of the MLC and ensure that the MMA accomplishes its goals?
Yes, as I mentioned earlier, I think we were pleased by both submissions that we received in the Copyright Office for the entities who wish to be designated by the MLC, recognizing that one of the most important goals of the MLC is to ensure that songwriters get paid for the use of their works, and that they reduce the amount of unclaimed, unmatched royalties. So that is something that both proposed designees have actually identified. One of the things that Congress has also already done to ensure that this process works effectively is to ask the Copyright Office, again, to do a study on best practices with respect to unmatched royalties and ways to reduce the unclaimed funds within the MLC. So that is one thing that Congress has already done. We will be preparing that report, starting to prepare that report as soon as the designation is made. And again, that report will come out in July 21, where we will be recommending best practices. And so I think once the report goes to Congress, as well as the MLC, ensuring that those best practices are actually adopted that we recommend, I think will be a key aspect of making sure that the system is working effectively.
Thank you. I'm an original co-sponsor as well of the CASE Act, and it's great to see so many creators here in the audience today. So currently it's cost prohibitive for many creators to enforce their rights in the federal court. So how will a copyright small claims tribunal or the Copyright Claims Board in the CASE Act not only benefit creators, but also benefit users of content?
Yes, as I said earlier in my opening testimony, it's really important for this system to work that the legal rights that are created actually have the people have the ability to enforce those rights. And so with respect to many smaller creators, smaller businesses, individual authors, right now the legal right is there, but it's not effectively enforced because they don't have the ability to get into federal court. So having this new alternative forum, I think, will be very important to really provide respect for the system and ensure that all who are supposed to benefit from the system are able to do so. One area that hasn't been highlighted a lot with respect to the CASE Act, however, is that it does also benefit users. You are able to, if you, for example, want to use a copyrighted work and are unsure whether it is a fair use, you are able to go into the alternative form of the CCB and actually get a determination of non-infringement. So it's not just to go after those who are pirating works, but those who are using works and want, again, the confirmation that they are allowed to use those works are able to go into that CCB with the streamlined process and get a determination of non-infringement as well.
So speaking of piracy, my home state of Alabama, like others, have seen an increase in movie and television production, bringing jobs and opportunities. But digital piracy remains a concern, and it can threaten possible future productions. The vast majority of people would never think of walking into a store and stealing a DVD. But don't give a second thought to streaming movies or shows online from illicit sites. So what suggestions would you have, and got 18 seconds, on ways that we can educate the public, and particularly young people, on the illegality of and harm of digital piracy?
Yes, I think that often, unfortunately, when people think of digital piracy, they don't think that it really does harm individuals. They just see the major artists and think, oh, well, if they don't get paid for that one DVD, it's not going to harm them particularly. But they don't realize the entire. Sorry,
Yeah,
I didn't do it.
It did go over.
Okay, it's gone on again? Okay, thank you. They don't realize the impact that piracy has not only on artists, but all of those who are really participating in the copyright ecosystem. So I think that, yes, as you mentioned, outreach and education on this issue is critical. Teaching the young people that, if you wrote a paper, you wouldn't want your friend to take that paper and pretend that it was their own. That's basically piracy. If you draft a song and somebody steals that song. So I think, again, once people understand the ramifications of how piracy really affects our culture and our ability to have a thriving copyright ecosystem and a thriving marketplace for culture, I think people will be more willing to understand the importance of protecting those intellectual property rights.
Thank you. Thank you, Mr. Chairman.
You're welcome. The time of the gentlelady has expired. The gentleman from New York, Mr. Jeffries.
Thank you, Mr. Chairman. First, I ask unanimous consent to enter into the record several letters in support of the CASE Act.
Without objection.
Thank you, and congratulations, Mrs. Temple, on your permanent elevation to the position. Continue to appreciate the leadership that you provide. I want to thank my colleagues, Chairman Nadler, Chairman Johnson, Ted Lieu, Doug Collins, of course, Congresswoman Roby, and Congressman Klein for their support of the CASE Act. Mrs. Temple, has copyright infringement increased significantly over the last several years?
Well, that's, an issue that we have studied. I think according to some reports, yes, copyright infringement continues to increase steadily, and the type of copyright infringement changes, for example, from, illegal downloading to illegal streaming. So that's something that is a current concern because the more effective laws that we have, the more effective pirates are in trying to circumvent those laws.
And under current law, when there's a claim for copyright infringement, that, of course, must be heard in federal court. Is that right?
Yes.
And that applies regardless of the amount in controversy. Is that true?
Yes.
So if the amount in controversy is $5,000, if someone wants to vindicate that right, they still have to bring a federal court case, correct?
Right, yes.
Now, I think you mentioned earlier today that the average cost of litigating a case in federal court is approximately $200,000 if you take it to trial. Is that true?
Yes, yes.
So in many instances, the cost of litigating in federal court is often higher than the damages that one may be seeking as a petitioner. Is that true?
Yes, yes, it is.
So is it fair to say that as a result of this sort of vexing situation, you have creators, visual artists, others who are left with a right but no remedy to vindicate that right? Is that true?
Yeah, and that's one of our key conclusions.
And do you support sort of a less burdensome alternative, such as a small claims court like tribunal housed within the Copyright Office?
Yes, and we issued a full report, as mentioned, recommending the creation of just such a court within the Copyright Office in 2013 with our small claims report.
And in terms of that 2013 report, that system that you recommended, I think, would be overseen by a panel of 3 copyright experts called the Copyright Claims Board?
I don't know if we called it the CCB, but yes, it would essentially be the same framework that is in actually the current case act.
Okay, and it would allow petitioners and respondents to participate without an attorney and without necessarily appearing in court, is that right?
Right, and that's the main purpose, allowing people to appear, for example, pro se, so they don't have to spend that $200,000. Also, they might be able to utilize, for example, law students who are able to come in and help them. And I know under the Case Act, the claims attorneys who are part of that bill would also be able to help guide those who are pro se in how to file their claims as well, which will be a very helpful aspect of the law.
Also, do you think that there's value in having copyright experts who will be part of the tribunal sort of assess the merits of a case and determine what, if any, damages would be available in the context of a dispute?
Yes, copyright can often be very complex, and that is why we did recommend in our report that the CCB or the whatever small claims tribunal have a authority by having expertise in copyright law. So at least 2 of the people who would be appointed would actually have to have expertise, both representing copyright owners as well as users.
And I think the 2013 report also recommended considering imposing a ceiling on the damages, is that right?
Yes.
And as far as you understand it, does the Case Act sort of incorporate those recommendations by setting a $30,000 cap for each dispute and $15,000 per work in terms of claims that are brought before the Copyright Review Board?
Yes, and that was our exact recommendation in our 2013 report.
Okay, and in terms of the importance of individual artists being able to vindicate their rights under copyright, could you just speak to the significance of it? Many of us have noted that Article 1, Section 8, Clause 8 of the United States Constitution, which gives Congress the power to regulate intellectual property law in order to promote the progress of science and useful arts, is sort of at the core of the founding of this nation. And so to have a circumstance where you have artists who have a right but no remedy and can't vindicate that right seems inconsistent with one of the foundational principles of the United States of America. But I'd be interested in your thoughts.
I couldn't say it any better. I will say that I certainly agree. We have recognized that individual artists and creators are really the backbone of our copyright ecosystem. And so having a system where those individual artists and creators aren't really able to participate and legally enforce their rights really isn't an adequate system at all. And that is why we do support a small claim, so that those individual artists and creators are able to have a forum in which they can vindicate their rights.
Thank you for your service. Thank you for your testimony. I yield back.
Gentleman yields back. The gentleman from California, Mr. Liu.
Thank you, Mr. Chair. Thank you, Ms. Temple, for your public service and for being here. My district in Southern California is home to a lot of creators. The Music Modernization Act was very important both to America as well as my district, and look forward to your office's implementation of it. My first question is, how will artists and songwriters and creators be able to comment on or give feedback to your office regarding the implementation of the MMA?
Yes, so they have already been able to participate and provide comments in response to our designation or our proposed designation of the MLC, which is the first regulatory activity we have under the MMA. We received over 600 comments from individual artists and others interested in providing their views as to which entity should be designated as the MLC. And then after we do designate, there are a number of regulatory implementation activities that we have to engage in. For each of those activities, we will go through a formal rulemaking process where we will seek comments from all of the public and especially, of course, those affected by the MMA so that they will be able to participate in that process.
So if a creator is watching this and they want to know how to submit a comment, how do they specifically do that? Do you have a website? Do you...
Yes, we have a website. In fact, just the day that after the MMA was implemented, we put a specific web page with FAQs about the MMA and the importance of the MMA to individual songwriters. We encourage songwriters and anybody who is interested to come to our website, our Music Modernization website page, and actually get further information. They can also sign up for various notices that we put out anytime, for example, that we do a regulatory process. We will issue a notice. We will tweet about it, but we will also send it out to our subscribers so they are aware of it. So we encourage them to sign up with the Copyright Office so they can get those types of notices as well.
Great, thank you. Once the Mechanical Licensing Collective is stood up, how will it be held accountable for accurately distributing royalties?
Yes, I mean, I think that there are a number of provisions in the MMA that are critical and important to ensuring that whatever designation is made, that the system and the entity that is designated will be appropriately ensuring that songwriters are actually able to get their royalties. Again, we will have a number of rulemakings to ensure that the process is working effectively. There are audit right responsibilities in the Music Modernization Act itself that provide that, for example, the MLC will have to provide an audit that will then be made public and sent to Congress as well as the Copyright Office. And then again, we do have regulatory authority to help to implement and effectuate the Music Modernization Act if there is something that we feel needs to be clarified, for example.
Thank you. I'd like to ask a question on intellectual property theft. A recent study showed that it was around $225 billion in cost to the U.S. What are some of your greatest challenges in fighting back against that?
I'm sorry, I didn't hear you.
I'm sorry, against IP theft.
Yes, I mean, as I said, we aren't an enforcement agency, but we work closely with the wider United States government to ensure that, again, the U.S. has strong protections in its law to ensure that we can fight effectively against piracy. I mentioned earlier that, unfortunately, as we update our law, often the pirates update their activities to try to get around our laws, and so one of the critically important things for us to do is just ensure that our law does keep up to date and that we are able to, and Department of Justice is able to effectively go after the pirates despite or however they are operating so that we can ensure that piracy does not continue to rise. And so we are working, continuing to work closely with Congress and with the Department of Justice and others who are interested in ensuring that the laws are kept up to date to be able to address the rising cost of piracy.
Thank you. So my understanding of NAFTA 2.0 that's being negotiated is that there's a notice and takedown system for infringement, but that if a member state meets certain legislative requirements, that's sufficient to comply. Do you believe that both Canada and Mexico will be able to comply and actually enforce that?
Yeah, I mean, we work, closely with the interagency on any trade and treaty negotiations. We participated in on the delegations and ensuring that the provisions of the updated USMCA do reflect the U.S.'s position in terms of the strength of IP laws, and we feel that the resulting provision is a good one, and that we are hopeful that our trading partners will be able to effectuate that.
Thank you. I yield back.
I thank the gentleman. The gentlelady from Texas, Ms. Escobar.
Thank you, Mr. Chairman. Thank you so much for your testimony today and for being here to answer our questions. Only one entity, the Digital Music Association, has made a bid to become the DLC. DIMA comprises executives from Apple, Spotify, Google, Amazon, and SiriusXM. Do you think smaller digital music platforms or new entrants have been overlooked by these large corporations?
Well, I will say that, the process to be designated as the DLC is an open process. So anyone who wants to be considered as a entity to be the DLC is certainly, or was certainly allowed to provide a submission to be designated. It wasn't limited to just the larger corporations. It just so happened we only received one submission to be the DLC, unlike the MLC where we did receive two designations. Under the MMA, we don't actually have to choose a DLC. The DLC does have to comply with the statutory requirements of the MMA. So we will thoroughly look at the submission that we received from the one applicant and ensure that it does reflect the goals of the statutory provisions, and then we will make a decision as to whether that entity should be designated as the DLC.
Okay, thank you. If Congress does not reauthorize the Section 119 license, should it play a role in establishing another market-based alternative, or should the market play out on its own?
Yeah, we have said with respect to the Section 119 license specifically, that again, that license has really, reached its limit in terms of its effectiveness, and we think that the marketplace itself has been able to rise up, so we don't think that there necessarily needs to be an alternative to the Section 119 license, but instead, we think that the free market would be appropriate to allow for those entities who had been using the license to be able to compete effectively.
What impact would the reauthorization of this section have on the Copyright Office? And is there any burden in maintaining the Section 119 license?
Yeah, as I said, for several years, we have recommended to Congress that they sunset that license. We will obviously continue to administer the license and to distribute royalties if the license does remain. But it is something, again, where the royalties under that license are dropping and they are continuing to drop. And so we just don't see that license as being an effective way to support the copyright ecosystem. Instead, we think that the free market at this stage, again, is more appropriate. So we will continue to administer the license if it is reauthorized, but we do strongly believe that over the course of the last few years, it's really been obvious that that license is no longer needed and that it should be allowed to sunset.
Do you think the Section 119 license diminishes the value of copyrights?
Well, we have always said that for compulsory license, which does allow for the use of copyrighted works without the permission of the copyright owner, that they should only be done in instances of true market failure. And so if there isn't a market failure, and right now we don't think that there is, then we don't believe that the compulsory licenses are needed any longer. And that's how the copyright ecosystem should actually work. And so because there's no more market failure with respect to the need for a Section 119 license, we do think that, again, it is appropriate to allow the market to take over.
And what new legal or policy issues does the office foresee becoming important over the next few years? Are you planning on undertaking any new initiatives?
Yes, as I mentioned earlier in my testimony, I think in response to a question, we do have our Section 512 study that is still ongoing that we hope to issue by the end of this year. So looking at how effective the Section 512 notice and takedown regime with respect to piracy and the balance that it's supposed to effectuate within the system will be, I think, a critical aspect. We may have recommendations to Congress on that issue. We are also very interested in Congress potentially addressing the issue of illegal streaming. Again, as I mentioned, right now the penalties are really not on par for violations of the unauthorized use of public performances in contrast to the felony penalties that are in our law for violations of the reproduction and distribution rights. So I think looking at illegal streaming is certainly an area, and we actually did just recently receive a letter from Congress from the Senate side on this particular issue that we will be responding to in the coming weeks as well.
Thank you. Mr. Chairman, I yield back.
Gentlelady yields back. The gentlelady from Pennsylvania, Ms. Dean.
Thank you, Mr. Chairman. And may I add my congratulations to you, Director Temple, for your recent appointment. It's terrific and exciting. I wanted to ask you 2 areas of inquiry, some of which you've touched upon. But in particular, you mentioned the analysis of overall workforce needs in your 2020 study. So when you look at needs, I'm wondering specifically what areas are you looking at, and what do you hope might be some of your takeaways? What are some of the biggest challenges and threats? So a little more information on the 2020 study.
Yes, in terms of the Copyright Office workforce needs, yes. So one of the things that we have said is that when we're modernizing the Copyright Office, we know it's critical to focus on IT, but we don't want to just focus on IT. We want to modernize our entire systems. We want to make sure that our workflow and our processes are really being modernized as well. We want to make sure that we have the right positions that reflect either our new IT systems or the new ways that we are going to have to do our job. So right now we are working on having several contractors come in to assist us with that process. We already have the Office of Personnel Management in our office right now, which are looking at our position descriptions and our positions to make sure that, for example, they're adequately graded. We have enough. They will be in the office until 2020, and then they will issue a study on that issue. Then we are also going to be engaging with a contractor to help us with business process reengineering, looking at the workflow aspects of our office to make sure, again, that we have the most effective and efficient processes. And then we are finally looking at organizational change management. We are going to bring in a contractor to help us with that area as well. We understand in a business transformation of this magnitude, it's critical that we have the buy-in of all of our staff and that they understand how their positions may change and are supportive of that. And so we're going to have a consultant come in to help us with that. So we have a number of areas that we are working on to kind of support IT modernization and modernization of the office as a whole that really aren't focused exclusively on the IT development side.
Are you also looking at diversity and inclusion across the board in the organization? I serve on the Diversity and Inclusion Subcommittee in Financial Services, and it's interesting to take a look at organizations. I had a roundtable in my district. We had business, we had law enforcement, we had educational leaders. As part of your study, are you looking also at that, not just a percentage of diversity, women, people of color, those who are disabled, all kinds of diversity, but across the spectrum of the Copyright Office?
Yes, I take those issues very seriously myself personally. We are working with the library. The library actually just did develop a group library-wide to look at diversity and inclusion issues. So we have my senior advisor, actually a direct report of mine, is actually working on that group. So she is going to be helping the library, library-wide in terms of those initiatives, and is also spearheading those initiatives for me personally within the Copyright Office.
Some of my common sense takeaways from having conversations about that is, number one, sometimes people just think their offices are diverse, and then they actually take a moment to look around, and then they find they aren't. So it's being sort of deliberate and intentional about making sure you're looking at that. And number two is sort of setting goals. So I'm delighted you're looking at that. I'll flip real quick in 1 minute I have remaining. Can you tell us about any plans you have to evaluate or potentially outsource additional functions, privatizing any functions that you might be doing, or are you trying to, in your overall study and modernization, not do that kind of outsourcing?
Yeah, I will say that we think that it's important that the copyright system of the United States is run by the United States and is controlled by the Copyright Office. So that is the main focus. We are, of course, looking at creative options for resources and funding. For example, we are exploring the possibility of no-cost contracting as part of the way to fund our IT modernization. So while we think it's important to maintain the Copyright Office IT systems within the Copyright Office, we are certainly willing and are looking, right now at ways to creatively fund the development of that system.
Terrific. Thank you, Director Temple. Thank you, Mr. Chair. I yield the remainder of my time.
End of time, the gentlelady from California, Ms. Bass.
Thank you, Mr. Chair, and let me join everyone else in congratulating you on your position, and I enjoyed our conversation. Look forward to working with you. The Music Modernization Act presents a unique opportunity to address inequities artists of color have faced for decades due to a lack of access and representation. Today, there has been a 72% increase in on-demand audio streaming. Hip-hop surpassed rock as the most popular in terms of total consumption in the United States. And 9 out of 10 most streamed songs in 2018 were hip-hop songs. African American and Latinx artists, hip-hop and R&B accounted for 29.7% of all streams in 2018, more than doubling rock. This is also at a time when Latin music has experienced record-breaking revenue growth due to streaming in both English and Spanish. The MLC will be tasked with ensuring that owners of music composition copyrights receive royalty payments and maintain a music ownership database that will allow copyright owners to stake claims to their songs. So it's critical that the thought leadership driving this process reflects every type of music copyright owner. So when considering an entity responsible for the mechanical, licensing collective, have you considered the issue of diversity or encouraged diversity in its leadership?
I will say, yes, that is certainly an issue that we have heard some concerns about from some of the commenters who have participated in our rulemaking process. By statute, of course, the MLC does have to, the entity that is designated as the MLC does have to represent, be endorsed by and supported by the largest number of musical work copyright owners or the largest percentage of musical work copyright owners. And so that will, by statute, ensure that the MLC does have a kind of a diverse representation in terms of the types of artists that it will have on its board. We did receive one comment or a couple of comments about just the diversity in terms of ethnicity and race on the board as well. We were pleased that in response to those comments, we did ask questions of both MLCs, and both who have proposed to be designated as the MLC have actually submitted comments to us committing to actually having a diverse and considering a diverse board. So we're very pleased by the response that we received from both of the entities proposing to be designated, that this is an issue that they take seriously.
Excellent, excellent, thank you. Some have argued that the new blanket licensing system flips the burden from digital service providers to the rights holders and songwriters. Jeff Price, a board member of the American Music Licensing Collective, which is one of the candidates for the Mechanical Licensing Collective, said that, quote, unlike before where the digital service providers would have to fine you and pay you, now you have to know about the MLC regardless of where you are on the planet. So how do you respond to these concerns, and are they addressed in your designation process?
Well, I think that partially they're actually addressed in the Music Modernization Act language itself. There is an obligation on the part of the entity that is designated as the MLC to make sure that they do outreach activities to alert songwriters to the need to sign up with the MLC.
Do you know how they would conduct the outreach?
Yes, I mean, that is something that we did actually ask for information on from both of the designee, and so that is actually, in terms of how they plan on doing it, that is something that anyone can go on our website and see some of their plans in terms of outreach. They are also supposed to work with the DLC once it's designated, and the DLC itself is also supposed to provide outreach activities to those who come to their platforms, letting them know that the MLC exists and that they're encouraged to sign up. And then separately, the Copyright Office also has statutory responsibilities under the MMA to provide outreach and education activities. And so we are committed, once the designation occurs, to take seriously those activities and really ensure that we can do our part in supporting the operation of the MLC and ensuring that songwriters are aware of the need to participate to ensure that they are able to get paid and get their royalties.
And do you have a way of monitoring how that outreach is going?
Well, as I mentioned earlier, one of the main issues is to ensure that there are not a large number of unclaimed funds remaining in the MLC, and that is why it is important for us to conduct the study on best practices to reduce the amount of unclaimed funds. And so I think that will be a key area, us reviewing the practices of the MLC once it's designated, as well as best practices overall, and making recommendations to Congress and to the MLC itself in terms of, again, best practices to reduce the amount of unclaimed royalties that they might have.
Thank you very much.
Gentlelady yields back. The gentleman from North Dakota, Mr. Armstrong.
Thank you, Mr. Chairman. I know you had spoke with Mr. Klein and Ms. Roby and touched on digital piracy, and you spoke to the Copyright Office role on this subject. I'd like to highlight some findings from a recent U.S. Chamber of Commerce and NERA Consulting issued a study on the impacts of digital video piracy on the U.S. economy. As of 2018, there were more video streaming subscribers compared to paid TV subscribers, approximately 500 licensed online and approximately 500 licensed online video portals. 26.6 billion viewings of U.S. films were digitally pirated each year, costing over $29 billion annually. You mentioned that this harms not only the content creators, but also the broader economy. And I know that your office is not the enforcement agency, but can you explain current enforcement authority to prevent such piracy?
Yes, the current enforcement authority is, handled by the Department of Justice. Again, as I mentioned earlier, we do work with them closely on policy issues with respect to IP rights and updating our laws. We also work closely with the Department of Justice, the Patent and Trademark Office, and other parts of their agency to ensure that our trading partners also have strong IP laws in their regimes. And so that's one thing that we do when we support the interagency on treaty and trade negotiations to, again, ensure that the global copyright ecosystem does protect strongly the copyrights of individuals and of businesses.
And I'm assuming pirating technology is always, it's a constant battle, which will be to my next question. And no matter how many enforcement agents we have, if there's 26.6 billion pirated viewings, you're not going to get it at the viewer side. You have to get it where it's being pirated. I just can't imagine the monumental task that this is.
Yes, it certainly is a monumental task, and I think that is why there's just not one way to address it. Certainly, making sure that we have a strong IP framework is an important aspect of it. But we're also encouraged by voluntary initiatives where digital platforms and content creators are working together voluntarily to address this issue. So that's another area that can really help to combat the rising piracy as well.
And you recommended that we continually update our laws to keep up with piracy. What policy changes, can we make either in the laws themselves or allowing these agencies to adapt more quickly to better protect this content?
Yes, as I said, making sure that we are reflecting the way that piracy occurs is one of the most important things that we need to do. So updating our laws, for example, to provide for, felony penalties for illegal streaming is something that, again, we strongly support and have supported in the past. We are, as I mentioned earlier, also reviewing the notice and takedown regime of Section 512 to see whether it's still providing the balance that Congress intended and whether there are areas that need to be tweaked in that either through legislative change or through additional voluntary initiatives. And so those are some of the ways that both Congress and the Copyright Office can help to ensure that piracy is combated.
And I guess this is just kind of my last question, and I'm not sure there's an answer for it, but we do a really good job of, I hope at least sometimes we do a really good job of dealing with the issue in front of us. But in this universe, how do we promulgate policy that allows us to deal with something we don't even know exists yet that could come on the horizon in 6 months?
Right, that, again, is the perennial issue in terms of trying to get ahead of the pirates. Anytime we have new technology, technology can often be used by pirates as well. So I think, again, having a multi-pronged process to get out ahead of it is important, ensuring that our copyright laws are kept updated, but also ensuring that there are effective ways for, the industries themselves on a voluntary basis to work together to address piracy, I think is an important aspect as well.
Thank you. I yield back.
The gentleman yields back. The gentlelady from Texas, Ms. Jackson Lee.
Thank you very much, Mr. Chairman. It's stunning that we have not had a hearing since 2015, so I congratulate the chairman and ranking member for a very important hearing, and as well congratulate Ms. Temple for her appointment, moving from so many different positions, but now the person. And so again, congratulations to you and your team. I too want to focus on the Music Modernization Act and also the question of modernization dealing with the technology in your office, which I think is extremely important. the status of the Copyright Office IT, and at the same time, what kind of firewalls are you putting in place to avoid hacking, the infringement from foreign adversaries, to be very honest, because what you have may have some measure of intelligence to it in terms of its quality or value to international operators. But let me raise this point. Some have argued that the new blanket licensing system flips the burden from digital service providers to the rights holders and songwriters. Jeff Price, a board member of the American Music Licensing Collective, AMLC, which is one of the candidates for the Mechanical Licensing Collective, said that unlike before when the digital service providers would have to find you and pay you, now you have to know about the MLC regardless of where you are in the planet. So how do you respond to these concerns, and are they addressed in your designation process? Question number one. And Price also estimates that the new system could leave $4 to $5 billion of accrued royalties undistributed, which concerns me. I've lived with the music licensing issue and trying to balance it for many years in this committee, and we did make great progress in the past year. Price also estimates, and so what measures can be taken to ensure that rights owners are properly compensated and not unduly burdened in collecting that compensation?
Yes, thank you for the question. This, again, is a very important one, and it's a critical part of the whatever entity is designated, that they ensure that they reduce the amount of unclaimed royalties. I will say that we are unaware of where Mr. Price got the figure of $4 to $5 billion. That did not come in any of the comments that we received in terms of the possibility of unclaimed royalties, so we would be interested in terms of where that estimate is coming from. But we do think, again, that there are specific provisions in the statute that will help to reduce those unclaimed royalties. Again, in addition to this having to be a priority of whichever entity is designated, by statute, the entity has to create an unclaimed royalties a committee to review these issues. They have to provide audits to ensure that they are operating effectively. Those audits are going to be made available to Congress and to the Copyright Office. And then again, we will be undertaking a full study that will seek comments from all of those who are affected by the MMA to ensure that there are best practices implemented by the MLC to reduce the amount of unclaimed royalties. And again, that study will be issued in July of 2021.
So your action item would be that you'll be studying the processes that have been established. Well, let me follow up by saying, under Title I of the Music Modernization Act, digital music providers such as Spotify and Apple Music will soon be able to obtain a blanket license. So how will the Copyright Office help ensure that the transition to the blanket license system will be seamless?
Yes, we are, committed to helping to make sure that that process works effectively. We, again, immediately upon the passage of the MMA, issued certain rules and regulations that were required primarily for the pre-1972 sound recordings part of the MMA, and then now are in the process of implementing regulations for the Section 115 aspect of the MMA. Once we designate the MLC and the DLC, we will then work closely on implementing regulations. Again, we have to do regulations such as the form and type of notices of blanket license, the form and type of notices of license activity, usage reports, usability issues, interoperability issues, as well as privacy and confidential consideration of privacy and confidential information. So we have a lot of work to do,
Right.
And we are committed to
Let me get these two other
that.
questions in. Let me try to understand how your IT is working to avoid breaching and security breaches, and then two, your outreach to minorities who need that kind of outreach as you go forward to understand this process.
Yes, so in terms of IT modernization and the security of our systems, that is a primary goal of our office, to ensure that our systems are secure. We obviously take in a lot of very important and valuable information, both just information as well as the data and deposits themselves. So we think it is critical that the Copyright Office...
Minority outreach? Minority outreach?
And the minority outreach, in terms of minority outreach, again, that's a critical area. We are expanding and have expanded our outreach and education program recently. We just recently had some students actually from the Hispanic Bar Association in our office to encourage them to seek IP law as an appropriate career. I just recently spoke at the Howard University about copyright and social justice, which is something that a lot of people don't equate copyright with, but copyright is an aspect of social justice. So that is an area that I personally am interested in and that we have been pursuing in recent months as well.
Thank you, Mr. Chairman. Thank you very much. Congratulations.
Thank you.
Time of the gentlelady has expired. The gentleman from Florida, Mr. Deutsch.
Thanks very much, Mr. Chairman. Thanks for holding the hearing. Thanks to our witness for being here, and congratulations on your formal nomination. I know you've been doing the job for quite a while, and I appreciate your service and willingness to lead the office into the 21st century. I just want to follow up on some of the questions that my friends, Mr. Nadler and Ms. Jackson, have already touched on. As co-chair of the Songwriters Caucus with my friend Congresswoman Roby, we meet with songwriters from across the country, and there's been a good discussion about the MLC and compiling the information for the MLC and matching the information to songwriters. I just wanted to make sure I understood on the issue of market share. Market share is going to be determined based on streaming and ownership information, but obviously if the database is incomplete, then payments could end up poorly representing the actual marketplace. Statute provides discretion. I just wanted to reemphasize some of what has already been discussed about the focus being on making sure that this is done right, obviously not focusing solely on accomplishing a task in time for a deadline, which would then lead to rushing to make payments from unmatched funds before the database is complete, as complete as possible anyway, and making sure that the pool is as small as possible. That's the way you're approaching it. I just want to confirm that.
Yes, and we were again pleased that both of the designees, or both of the entities that wanted to be designated as the MLC, agreed with the interpretation that unclaimed funds cannot be distributed until 2023. So that will ensure whoever's designated as the MLC time to actually develop a framework to reduce the amount of unclaimed funds.
Great, I appreciate that. Second, as you know, Cloudflare is a large company, provides a number of services related to internet security and the delivery of content over the internet. There's no doubt services are valuable to its many legitimate law-abiding customers. Indeed, I've recently seen reports that the Copyright Office uses its services as well. I've also seen, however, some concerning reports of what appears to be a darker side of the use of Cloudflare, describing its widespread provision of services to known bad actors, including hate speech sites, counterfeiters, even terror groups, according to one of the reports that I read. And I just ask whether you would agree to review the Copyright Office's use of Cloudflare in light of these really disturbing reports.
Yes, no, that is an important question. As you know, post-centralization of IT within the library, those issues are decided by OCIO, the librarian's OCIO. We have raised this issue in light of stakeholders' concern with OCIO that some have questioned the use of that particular entity, and so we are hopeful that they will review that issue.
So you've raised it and asked them to do what?
We asked them to review the issue to see if it's appropriate for them to use that entity.
Okay, I appreciate that, and we'd appreciate being kept abreast of that analysis as well. I'd like to ask about the fast-paced nature of creation and publication online today. Photojournalists obviously tweet images of breaking news. Artists and poets post moving works on Instagram. Authors now write on blogs, and this modern day publishing gets done in an instant. And the tools make it incredibly easy to share creative content online, but obviously there are challenges for your office. If you could talk about some of the challenges and opportunities that you see as you work to keep pace with protecting those creators who share their work online, who are doing really important work, creators who are fortunate to have copyright protection, but if they don't have the benefit of statutory damages, their work then in the blink of an eye is then put at risk. So if you could just talk about how you see this going forward.
Yes, and we know that this is a critical issue. Obviously, in order to get statutory damages, they have to have registered within a certain amount of time with the Copyright Office, and so we want to make sure that, again, as we develop a modernized system, we make it as easy as possible to register, and also to register, a high volume of works. We understand, for example, photographers will take thousands of pictures in one session. Right now, we have a group registration option for photographers that does allow them to provide up to 750 photographs with us at one time, and that's to ease the burden of individual filings of copyright registration applications. In the future,
If I can just ask, has that been successful since February when it was implemented?
well, I will say, it's been successful in the sense that it allows the Copyright Office to adequately use its resources to handle a large volume of photographs. We do understand that there are some concerns from photographers that number is too low. And so one of the things that we are looking at as we, again, continue to modernize are whether there are ways that we can use technology that we would be able to more quickly review those types of claims where they're high volume claims. And so that, yes, we would be able to raise that limit beyond 750 if we're able to use technology. Again, one of the things that we would love to do is, for example, allow people to register through their mobile telephone so that they're able to do it easily, use APIs to be able to be interoperable with our office. So those are some of the areas that we're exploring in terms of modernization right now.
Terrific, great. Thanks very much.
Thanks.
Gentlelady from Texas, Ms. Garcia.
Thank you, Mr. Chairman, and Ms. Temple, thank you for being here, and I too congratulate you. And I do apologize, I did have another hearing that I'm sort of bouncing around from one to the other. But so if I ask anything that you've already talked about, please excuse me. But I wanted to start with picking up with my colleague and fellow Houstonian left off, Congresswoman Sheila Jackson Lee. In the blanket license that you're going to be able to give now to Spotify and Apple Music, is there a reason that a blanket license was chosen versus the old song-by-song licensing, and will that cause any additional challenges for you?
Yes, so a blanket license was chosen to really further effectuate the efficiency of the music licensing system. The old song-by-song license, I mean, as you can realize, these individual services are using millions and millions of works. So they, if they cannot find the songwriter or copyright owner in our database, they will have to file it. For example, they had to file notices with the Copyright Office to be able to get a license under Section 115. We received in millions of individual NOIs pursuant to that song-by-song license approach. And so that really was not the most efficient way to market or music licensing under...
Do you see any issues arising from that?
Arising from the...
From doing the blanket license?
No, I mean, I think that, this is, again, something that the Copyright Office has actually reviewed for several years. We supported the creation of a blanket license under Section 115 for many, many years, even before our Section 115 report in 2015. So this is something that we think will actually further support the efficiency of the music licensing market and actually allow songwriters to get paid more effectively.
Right. Then I wanted to also talk a little bit about the piracy issue. I realize that DOJ does the enforcement, you do not, but what steps are you taking, or are you taking any steps now to kind of monitor and create the data? And can you share with us today if there's, since you started doing it, if you're already doing it, how big the increase is? Is it as big as we think, or we don't even know the full of it?
Yeah, I mean, I don't want to get out of ahead of us in terms of the fact that we're actually right now doing in the process of completing our report under Section 512, and so we'll have some more specific data once that report is released.
When will that be released?
So that will be released by the end of this year. And so that is, again, one of the areas that we're working on the policy side to ensure that our laws are kept updated to deal with piracy. Again, we also work with the interagency to ensure that our copyright framework, both domestically and internationally, is strong. So we do support delegations for treaty and trade negotiations as well. And then finally, you know, I think the U.S. government has been interested in supporting, if it can, voluntary initiatives between digital platforms and content creators to see if there are things that they can do even outside of specific laws to address this issue voluntarily.
Well, but to assure the public today, I mean, you are telling me that you are monitoring.
Yes.
And you are looking at it. And you're looking at it not only here in the continental U.S., but you're looking at it globally?
Yes, that is we have a full international and policy affairs department that actually helps assist, again, the rest of the United States government as they look at these issues. We often review, for example, the laws of other countries to see if they reflect the strong IP framework that we have here in the United States, and we will provide suggestions to them to consider as they're updating their laws to ensure that, again, that they're effectively addressing piracy as well.
And you, as a representative of the United States, are fully engaged and fully participating in any global forums or, coalitions that are looking at this topic?
Yes, we, by statute, participate in foreign delegations, as mentioned. We work very, very closely with the United States Trade Representative. We also serve on delegations to the World Intellectual Property Organization, so that's something that we do regularly.
Right. Very quickly, I just want to go on record as being supportive of the small claims court. I think anything we can do to make it easier for the average everyday American to be able to go through this process would be very helpful to many people that we represent, and I hope that you can support that and assist in any way you can if that were to become the law.
Yes, we do fully support that.
All right, thank you. Yield back. Thank you, Mr. Chairman.
Gentlelady yields back. The gentlelady from Arizona, Ms. Lesko.
Thank you, Mr. Chairman, and thank you, Ms. Temple. And I think since you're going to be done pretty soon, because I think I'm the last one over here at least. I think there was questions already answered, because I was going to talk about Stellar and the reauthorization, or your recommendation not to reauthorize it. And I was told somebody asked you what will happen to the satellite subscribers that utilize Section 119 license. But more specifically, I have concerns about maybe the people that have recreational vehicles, truckers, those type of folks. What are their options going to be, and are you considering grandfathering in some customers?
I think, as I said earlier, we've looked at this issue for many years. We do think that the usage of that license has really dropped significantly, and so that there will not be a significant market harm to those rural communities that have relied on the license in the past, and that the free market will allow for, other entities to come up and to allow for the actual usage of various satellite transmissions. So we don't think that it needs to be done rather through a compulsory license, but it can be done through the free marketplace.
And Ms. Temple, since I wasn't here for your answer, how many consumers utilize that service?
So right now, I think it was mentioned earlier that there was an estimate that there were about 800,000 subscribers, and I think you mentioned that in your testimony as well. One of the issues that we recognize is that it's not clear, and we did ask, I think, that question of the services exactly what types of subscriptions they're reflecting. Are they household subscriptions or others? And so that is one issue that we are seeking further information on.
And Mr. Chairman, I guess I just want to say, please keep in mind these people, and even though it's a relatively small number, I know that when the service is taken away, I assume they're not going to be happy. So if you can get some more information on that, and I'll try to find out how many of these subscribers are in my district. And so thank you very much, Ms. Temple, and I yield back.
Thank you.
Gentlelady yields back. Gentlelady yields back. Being no further questioners, this concludes today's hearing. We thank the witness for attending and for her work. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. Without objection, the hearing is adjourned.
Thank you.